Hi, good afternoon, and welcome to today's edition of the Law and You. I'm your host, Attorney at Law Shellon Washington, licensed in the state of New York, licensed in my home country, Guyana, and licensed in Twin Island of Trinidad and Tobago. It's a pleasure to bring you this special edition of the Law and You today, guys. I have a special guest with me today, and we're going to be talking about trust and estates again today. But we're going to be giving you some different insights of how you can go about making your trust more perpetual and to continue that trust for more and more a longer period of times in terms of your generation. Joining me today will be attorney at law Clairmont Chung. He is joining us now. Hi, good afternoon, Claremont. How are you?
Hi, good afternoon, Sean. How are things with you? I'm fine. How are things with you?
Okay, it's great, and I would like to wish you a happy holiday season to you and your family.
Thank you. Thank you. And to yours as well.
Thank you. Thank you. And I also would like to take this time to wish our guests, all the viewers, a happy holiday season. We hope you have a great season this year. And we are going to get into it today. As I said, this is my colleague, Clairmont Chung. He is also licensed, he's dual licensed in the state of New Jersey and also in New York. And today we're going to it's a special edition, as I said. So we're going to be speaking about trust in estates and how to lengthen the lifespan of that trust, the best way to protect your asset, and we will get into it this afternoon. Clement, before we get into it, do you mind telling the audience a little bit about yourself? I don't believe I've had you as a guest on this show. I've had you on the Bench Shop show, but ever since I've started this new program, I don't think you've been here. So could you just tell the audience a little bit about yourself?
Well, I was born in Guyana. I'm from what you call the scheme. Born in La Penitence, Castle Housing Scheme. I went to primary school there in St. Pius off the Blissingen Road. I went to St. Stephen's as well for a little bit, and then at Queen's College. And I migrated. I was to the U.S. Emigrated, and went to college here in the U.S. and have been living here in the U.S. but going back and forth fairly regularly. This year alone, I've been to Guyana at least 4 times. I just came back like 2 weeks ago, so I'm in touch with what's going on. I'm not, entirely foreign.
Right. So you guys know that Claremont is also Guyanese and we're from the same country.
Mm.
So let's get into it. So I've been discussing on this program multiple times. I've told people ways to protect their assets. So I want you to tell the audience, what do you think is one of the best ways to protect assets and to pass it down to another generation?
Well, some background first. I think we probably have agreed that trust is the way to do that. But most times when people ask me about trust, from the questions that they're asking, my interpretation and my understanding of what they're trying to do is to have this money, this asset that they've worked all their life to develop, to last beyond them, to their children and their children's children, and essentially forever. And though there are ways to do that, many states do not allow you to leave things for people who are not yet born, so that and to extend it into perpetuity. There are ways to do it, but there are some states that pass laws against trying to do that. But
Right.
I want to say, before we even talk about that, like the main reasons, however, that I offer trust as a solution is not for it to live forever, even though that is what a lot of people want to do. It's really to reduce the cost of the actual transfer from you once you've passed on to someone else. And so rather than do a will or die or pass on without a will, and in which case you'll have to pay probate fees, pay an attorney most likely, pay court fees, and spend a whole lot of time, which is more money, getting to the point where you can appoint an administrator or an executor. A trust has its own power, It operates on its own power. You don't need to go to a judge to give you permission to do what the trust says. So that is really the main reason I offer it as an option. But as we discussed, passing on, having it live forever, is something we could also talk about.
Right. Before I even get into that, I'd just like to give a shout out to one of my clients. I see he's there. Hi, Andres. I'm giving him a shout out. Anyway, so yes. So that is, I think Clement was quickly mentioning, it's the rule against perpetuity. So the rule against perpetuity, as you guys know, those of you who are from Guyana who are watching, we do not create trust that operates against the rules against perpetuity, because the rule in Guyana, the system is based off of the jurisprudence there is based off the British system, which does not allow. But as you know, in America, there are some states that permits you to go around that rule, or the rule is just not operative as it is in countries like Guyana. And one of the ways I think I've done it for clients, is, which I would like us to focus a little bit on, the living trust. Before I even tell, and the living trust, you could have an irrevocable or a revocable living trust, which I've discussed before on this program. And as you know, the irrevocable living trust is not one that could just be terminated at any time. It's irrevocable for a reason. And in order to terminate it, there's limited circumstances under which you would be allowed to terminate. And then there's the revocable one, which is the one that we probably will focus on right now. So I'm going to like to ask Clement, just tell the audience a little bit about the revocable living trust. And then we'll get into how you could get around the rules of perpetuity when it comes to the revocable living trust.
Well, it's probably better to compare it with the irrevocable in order to get the full meaning of what the revocable is. I mean, though you're transferring property into what is essentially another person. I think that's the best way for people to think about what a trust is, and not to be intimidated by the term. Is as if you are creating a person. Now, I know we don't have those powers; that those are very higher power. But for the sake of the law, that person is called a trust, and we can give it any name we want, just like a child. Say whatever your name is, you could have the Shellon Washington Family Trust or whatever name you want to give it. You can also assign it a social security number if you wish. You don't have to. You can use your own social security number as if that trust was a very young child. And so, but it essentially operates sort of like as a person, but as a person who can accept assets. And the reason I compare it to a child is that the trust itself doesn't have a brain. The trustee is the person who determines how this trust is going to be conducted. The grantor is the person who funds the trust, who puts the value into the trust and appoints a trustee. Now, that can be the same person. You can be both grantor and trustee, especially in a revocable trust, which is what we're discussing now. So, most of the trusts that I would create, the grantor and the trustee is the same person, and they carry the same social security number. You put property, your house, your stocks, bonds, even bank accounts, 401ks, any asset. I don't think there's any block against any asset going into the trust. And then you, as the trustee, can manage it in much the same way as you would if you did not have a trust, that if you were managing it on the day to day. The benefit of that being, as we discussed, should something happen to you, the trust tells the trustee and the person who's going to take over after you, who you would name in that trust, tells them what to do, and they can go ahead and do it without state or court intervention. That's the beauty of it.
Right. And I think one of the most powerful aspect of the revocable living trust is your ability to actually put the assets into the trustee's name. Because as long as those assets are actually transferred, and I see a lot of people make this mistake in that they create the revocable living trust, but they fail to transfer the asset into the trust, and they leave the asset in the grantor's name, or the settler. The person who is putting those assets into the trust is called the settler. And a lot of times people fail to take the assets out of the settler's name and put it into the trustee name or into the trust itself. And that would create a problem when the grantor or the settler actually dies, because then the court is going to treat it as if the person died leaving the assets without the assets being in a trust, or in under a will or something, if the person failed to create a will. Now, one of the things is I think is really important about the revocable living trust is, like Clemma said, your ability to give it whatever name you would like to. And one of the ways to get around the perpetuity rule is to create, for instance, whatever your last name is. For instance, if my last name is Washington, I can create the Washington Family Trust, versus creating a trust with my name, my full name. I can just use the Washington Family Trust, which means anybody who falls under the heading family, they'll be potentially, not necessarily, but potentially a beneficiary under that trust. And I'm going to name all the people, because of the rule of perpetuity, who I would like to be a beneficiary under that trust. But then under that trust itself, I can make provisions for the trustee to name new beneficiaries, or for the beneficiaries to appoint other beneficiaries other than themselves. There's ways to make provisions for those things. And that's some of the ways to get around the whole rule of perpetuity, or the trust could be amended. There's ways to amend your trust. Since they're successor trustees, there's way to have another trustee take over if one trustee dies. There's ways and means for people to get around these rules. Clement, you said earlier, you said you usually prefer the trust to, as your, that's your preferred way of protecting assets, and or passing assets down. Do you propose any other way for people to pass their assets down, from generation to generation? What if they don't want to sell? Let's say they have an apartment building and they don't want to sell that apartment building, but they want to keep it in the family. They want the beneficiaries to benefit it for generations to come. What would you suggest that that person do in that
But
case?
there, you mean outside of a trust, there are other ways, but normally wouldn't recommend. But I will give the options and the dangers. One of the things is that you can transfer it to someone else now. If you have children and you want your children to inherit, rather than wait until you have passed, uh, for the court to intervene, or yeah, for the court to intervene, you can do that now. Now there are tax consequences that need to be considered, and the basis and of what are they going to be taxed on and so on. Is it a gift, or whether they're paying good money for it, are choices you might want to make. But if it's your child, more than likely it's a gift. But when they are ready to sell, if they sell, their tax consequences may vary, depending on the specific facts. But transferring the property now is an option, that you're free of it. If your child is somebody that you have a good relationship with, and you don't think is going to take the and sell it and spend the money and leave you in a nursing home or something like that, I think, I think that's a way to go. Of course, there's still the will, and in the worst case scenario, even though in some very narrow cases, you just leave it as it is and let it go to administration. Um, I would have to define that, but that's like the worst case scenario. The will is another way, but a much more expensive way than the trust. I think in the long run, you might pay more upfront to have a trust prepared, But on with the will, you'll pay a whole lot more to have that probated down the line.
Yeah, that's very true. I just one caution which I've discussed with you guys on the show before. If you go with the transfer option, as I did before, Claimant, I did mention a situation that I had before where a client did transfer his property to the mother of his child, and then once that child turned 18, she gave the property to the child. And while the man was still living on the property, the child was trying to evict his father and to sell the house, and the father had to file a lawsuit. So, what I usually tell people in that case, don't trust anyone. Just be cautious, and you can do a life estate, because in the event of a life estate, no one can sell your property or have it for their benefit until you die. You
Right.
will have your entire life estate, and they will have the remainder interest once you die. So that's the caveat with the whole transferring to your children right now. And like Clement said, the tax consequences also, and then the whole issue of whether or not your child is living in the state of New York, or whichever state you're trying to whichever state you're in, and you're trying to transfer that property to that child, you have to consider the tax consequences. In New York, there's a if you're a non-resident and you want to sell a property, there's a higher tax rate on that for you because of the capital gains. But if you choose to have a resident transfer, then it's a different story. The taxes is calculated differently, and you'll save yourself much more. Also, if you're living in the property as your primary residence, these are all things you discuss with an accountant and make a informed decision rather than making one where you're not too sure. And as always, guys, it's always important to consult with an attorney anytime you're going to make any decision as to what your assets or where you're going to put it or what you're going to do with it. These shows are only for informational, it's to inform you, it's not to give you conclusive legal advice. So you ought to know that even if you're watching this show, you like the information, it's still, you have the onus of consulting with an attorney before you make a decision. And guys, if you're looking for legal advice, my number's across the screen, 718-877-3100. As always, these shows are brought to you by the Washington Law Firm, located at 455 Utica Avenue in Brooklyn, New York. You can give us a call. Consultation is always free. There's a free 15 minutes consultation. Now back to the show, guys. We're discussing today, it's a special edition. We're discussing trust and estate, and not just a trust, but estate issues generally. And what some of the issues you will encounter if you choose not to do a trust claimant, as touch on some of them, either transferring your assets in your lifetime, protecting it, of course, with a life estate, or you can go by way of doing a will, creating a will. If you don't create a will, one of the things you risk is something called intestacy. Intestacy is a big one, Claremont. Do you want to break down intestacy so people could understand what is intestacy and why is it important to ensure that your estate is not passed under the rules of intestacy?
Okay, so I will, but I want to ask you a question you can address after the intestacy minute. Whether you had had issues in creating trusts with properties that are still mortgaged, and how have you been dealing with that? Because that's something I run into, and some banks are more aggressive than others, and some are more. But intestacy, as to answer the question, is dying without any provision to distribute your assets, and in that case, you leave the state, the laws of the state where you live or country, to make that determination for you. Now, they give certain percentages depending on what state you're in. If you're married, your spouse is entitled to a portion. I believe in New York is 35%. In New Jersey, you get something like that off the top, cash, and part of what the remainder is. So spouses are protected under the law. Children are not protected, but they do stand in line to gain on the in the test intestacy. On the under the will, you're not required by law to leave anything for a child. But with wills, you cannot disavow a spouse. A spouse has to get something once you're legally married, or that will could be invalidated. So bear that in. That's an important distinction. In a trust, it's unclear whether that could actually be done. I don't because the trust has its own power. Maybe there is a way to disempower. Don't tell anybody I said, right. I- and thank you, Shellon, for that disclaimer earlier that this is not legal advice. You can't go and do something and said Mr. Chung or Miss Washington told you what to do based on what you heard here. This is a discussion. Um,
Exactly.
so yes, intestacy leaves the distribution of your assets to the existing laws of the state, and someone has to be appointed. Anyone could apply to become the administrator of your estate. I don't know whether you want that. And one of the things, wills or trusts, is to appoint the person that you want. If you don't do that, anyone can apply once they qualify, and it could be a stranger to become the administrator of your estate. So
That's right.
be careful about that.
That's right, Claremont. Even the public administrator would have
Correct.
the ability to take over your estate. So you don't want to leave it to chances. And now I'm going to answer your question. To answer the question as to whether or not you could leave property in a trust where there is a mortgage. And just note, guy, this is a situation that happens very, very often. People would like to create a trust, but the property still has a mortgage on it. Now, there's certain mortgage provision. There are times when the city would give you mortgage. There's a specific type of mortgage that people take out to help them to close on a loan. And those type of mortgage, because it doesn't require a repayment, but it just requires that you hold the property for a specific length of time, like maybe 10 years, 20 years. And as long as you reach that required time, then the mortgage is automatically written off. So if you have that type of mortgage where you're given a certain amount of money by the city or whoever to close, most time it's funded by the government, it's funded by a state or something of the sort, and it has that restrictive covenant in it that you are not allowed to transfer your property until the time expires, the 10 years or the 20 years, then you will not be able to transfer out the property from the settler's name to the trust. Okay, you'll have to hold on to that property. You can create the trust, but you just can't touch the title on the deed. It's the same thing with a reverse mortgage. You got to be careful with reverse mortgages because all of them has a restrictive covenant in the agreement itself, telling you that you're not allowed to transfer the property from the name of the mortgagor. You have to hold on to the property until the mortgage is fully paid, and then you could transfer the deed. But if it's just a regular conventional mortgage with no restrictions on it, there's nothing that could stop you from transferring the property out from the settler's name into the trustee's name or into the trust name if the trust has a form and it has a tax ID number. But just note that if at any point you need to modify that mortgage, you will not be able to do so unless you transfer the property back into the settler's name. So you just have to be careful. There are all of these caveats that you have to look out for if you would like to transfer the property, the real estate more in particularly, out of the settler's name into the name of the trustee or into the trust itself. So those are some of the issues, Clement. Other than those, no restrictions, nothing to prevent the person. But if perhaps something happens down the road and they want to transfer, right? They want to get a mortgage or they want to modify the loan. The only person with the ability to do that is the original mortgagee, the person who took the mortgage in their name. And then the problem is also their name must remain on the deed. The bank wants to see that person's name still on the deed before it can do anything as it relates to that mortgage itself. And then there's another issue which I heard you raise earlier about the trust and about the spouse getting around the trust rules. I tell people all the time, if you want to do a trust and you and your spouse are living in that property, you cannot use marital assets to invest into that property. If you do that, you're going to be clouding the line as to where what is exactly trust property and what should be considered marital asset. That trust property must remain independent and distinct from anything that is coming from the husband or the wife. So when the husband and the wife work, they cannot take, except if they're paying a rent, Claremont, they can pay a rent to the trust. And then the trust use its money to pay the mortgage. But the husband cannot be paying the mortgage from money that he's working for. Likewise, the wife cannot be doing that, because that is marital assets getting commingled with trust property. And that is going to blur the line and create confusions. And for somebody, the door will be open for somebody later on to come and say, well, I'm entitled as part of marital assets being placed into this trust property to my interest in the property. All right.
I
Clement, do you go ahead?
I think you need to expand, clear that up a little bit. If you're married, there is a mortgage. You're both paying a mortgage. You're saying that that property should not be placed in a trust because of it's a marital asset.
The
Um,
the only way I feel that it would be doable, Claremont, is if both parties are in agreement and they have agreed in writing that even if they decide to divorce, neither party is going to dispute the fact that the asset is part of the trust, and nobody's going to claim an interest in the trust asset.
all right, I was gonna suggest or posit that you could do mutual trust or a mutual gift to the trust, and so there are two grantors named in the trust, and then you do sort of like a co-trust, if you will. That might be a way to do it, and then get it a EIN as opposed to using your personal social
Social.
security number to identify it. But again, these are just suggestions and ideas, and your situation. Every situation is going to be different, and you need specific input and feedback.
That's very true. The time is running up on us now, Clement. I want to give a shout out to my client, also John Thompson. I want to say thank you. Just give a shout out to you. I see saying good afternoon to myself and
Mhm.
Claremont. It's been a great show, Claremont. I want to say thank you so much for joining us this afternoon, and thank you for your insight. And I hope the public has gained something from this show that they'll be able to use. And again, guys, if you need legal consultation, just call the office. The number is right there on the screen, 718-877-3100. Consultation, as always, is free to you. My office is at 455 Utica Avenue in Brooklyn, New York. And again, today's show was brought to you by the Washington Law Firm. Thank you for all your support, guys, through the years. And I know it's the end of the year right now. So I hope you guys are going to have a great year next year. This is the last show for 2024. The next time you're going to see me, guys, is in the year of 2025 on this show. So I would like to take this time to extend greetings to you throughout the rest of this year. And I hope in 2025 we will continue to see your support. And guys, just remember, share this live, share, share, share. It costs you nothing to just click on the share button and share it, so as many people that need this content can have it. Clement, any closing thoughts before we go?
Now, have a great new year. Happy Kwanzaa to all of you, and I'll see you soon in the show sometime in the new year.
All right, guys. Thank you. Enjoy the rest of your weekend and enjoy your Christmas season. Thank you. All right. Bye.
Bye.